Hi, welcome to Judica County. I'm Ashley Penner and I'm an attorney with Whitaker and Hamer, and here with me today I have Cassandra Nicholas and Jordan Mackey, both also attorneys with the firm, to go a little bit deeper into an estate administration process. So I'll throw it to you guys. Is there just one estate administration or is there more to it than that?
There's a little bit more to it than that. There are several different types of estates that can be opened, and that's why it's important to bring quite a bit of information, what you can, regarding the decedent's assets and debts to your initial consultation, because those assets and debts help us determine which type of estate will be opened.
The way it can determine things like that is certain estates have to be opened if there's a certain amount of assets owned by the decedent at the time of their passing, independent upon who the family is. So, for instance, someone's spouse passes away and they want to make a claim towards $60,000 of that person's personal property without it being touched by creditors. They're able to do what's called a spousal allowance in North Carolina. It would not affect any real property in any way, but if the property is already owned together at that time, then everything else up to $60,000 could be transferred to the spouse. So that's why we'll ask for a copy of the deed or things along those lines, or maybe financial statements from you. Another thing that could happen if there's just a surviving spouse and there's a will that states everything is going to that spouse, is they could choose to do a summary administration. And that just states that everything is going to go to the spouse, including the debts or any claims that would be made against the decedent spouse. But before doing any of those, what you'll want to do is have a full idea of that person's assets at the time of their passing.
So I know that if there's a smaller amount of assets, there is an option for a small estate.
Absolutely. So if there's $20,000 to the person's name at the time of their passing, what you can do is called a small estate. Now, this also, if you're trying to sell that person's real property or their house, this would not be the option to take. But if there's just some personal property in the person's name that needs to pass the decedents, and it's under $20,000, then what you'll choose is a small estate. Now, if the surviving spouse is the only person still around, then it's up to $30,000. But it's really dependent upon the situation and the assets at the time of that person's passing.
So that really is a really important reason why we do need to know up front what assets there are. So it's important to look at the decedent's paperwork that they have in their home and mail that is coming in. So you can gather bank statements, which will need to be submitted to the court once an estate is opened, and to determine which type of estate is being opened. So Jordan did review summary administration, the small estate, and the spousal allowance, but there's also a full administration, and that's required when there's more than 20 or 30, whenever it's a situation where it cannot fit into one of those other estates that Jordan's already spoken about. So a full administration would require all of that financial information and a little bit longer process than some of the other ones. It would require the estate to be opened with an application for administration and an oath. And which application is used also depends on whether or not the person had a will. So it's important to look for an original will before your first consultation with our office.
So yeah, it sounds like there's quite a bit more to it. When you say it can be a lengthier process, what are we looking at? What is a client typically looking at in a smooth administration from start to finish? How long should it take typically?
So a full administration, a very typical amount of time is about a year. That from the time you open the estate, you have a year deadline for your final account with the clerk. Once it is open, you have 90 days until you need to file an initial inventory documenting all of those assets at the time of the decedent's death.
So before you really get started in this process, like you say, you really want to have gone through your paperwork and gathered everything so that you don't start that clock before you're ready to start giving over information.
Absolutely. Absolutely. It's not required that you know everything they own at the time you first come speak to us, but it will help everyone out and make the process much easier if you have at least a good idea of what they have to their name. Also, if they have any debts, it's a good thing to know about. So if you have any credit card bills or anything like that come in, it's a good thing to keep an eye on.
There are also circumstances where someone has passed and an estate won't need to be opened at all. So having all of that information up front is also useful to determine if our services are even necessary.
I know in a lot of my estate planning consultations, I'll talk to my clients about that very time, at the very least, when the time comes that they might need to administer an estate, to have a consultation with an attorney to just kind of get their bearings, get a roadmap, see if indeed there is anything they need to do. What do you see as some common pitfalls, places where we can hit a snag and that administration process may drag on a little bit?
There are some snags at the outset. Frequently when people are named in a will that may no longer have a lot of contact with the family, those people need to be brought into the process and contacted, and there may be some documents that they need to sign to even open the estate. And sometimes getting in contact with those heirs is a holdup to even opening an estate. Are there more that you see?
So that's really the biggest holdup we come across, and it starts at the beginning, and it can also happen kind of throughout, because at points the heirs or beneficiaries may need to sign receipts to get the final accounting or the annual accounting in, and those receipts have to be signed by them, returned to you. So if there's no way of contacting them to get them the money that they're going to be getting or the assets put in their name that they're going to be receiving, and then to get those receipts for that, it can cause delays in getting those accountings in, which is what in essence closes out the estate for us.
There are a lot of points that can be sticking points, but most estates do run smoothly, especially with a little bit of foresight and planning for what we need and that collaboration with clients for what they need to bring to us.
Yes, and along with what we were talking about earlier, a lot of the snags that could happen can be avoided by collecting as much information before the first consult or as soon as that information comes in and providing it to us at that point, so that something doesn't come in at the last minute that has to be resolved or given out to an heir or anything along those lines. Usually if all the information is provided, everybody's able to be reached, everything's going to run very smoothly.
Do you see a big difference in the administration process when someone does have a will versus when they do not?
Yes, absolutely. A will provides a roadmap for how the estate is handled, exactly who will be receiving what, and who is essentially entitled to administer the estate, who's responsible for making sure all of the decedent's last wishes are carried out. So the process with the court doesn't change a lot, but in terms of how assets are actually handled, it definitely influences those heavily.
Yes, it can definitely help at the outset too by naming the executor and who the decedent trusts to handle the assets at that point. I've had situations where a decedent has passed away with upwards of 8 to 10 children and not had a will in place, and all of those children had to renounce their rights to serve as executor. So just getting the estate started in that instance can be a little bit of a hassle. So if you have that will in place, it kind of at least gives you the starting point too of who you need to deal with and letting them know what they need to collect asset and information wise.
So I know we don't want to overwhelm potential clients. When you're coming in for an estate consult, it's frequently an emotional time when someone's recently passed. So we don't want to make it a scary or intimidating process, but we want you to be armed with this knowledge that if you bring us what you do have and what you do know about the decedent's debts and assets, we will walk you through the process and make sure that we can get the estate open and closed out in the smoothest way possible. And hopefully that is helpful for the clients to know at the outset.
Absolutely. Well, thank you both for joining us today. If you have any questions about estate administration, please reach out to the firm. You can call us at 919-772-7000, or you can visit our website at wh.lawyer. Thank you.